morning, Your Honors. I'm Wendy Parmet. I represent...
Hold on just one moment, please. We want to make sure that we have you on tape. All right, let's proceed.
Thank you. I'm Wendy Parmet, and I represent Dorothy and Finch et al., the plaintiffs in this case. 5 months ago, to the day, this court ruled that Section 31A, a 2009 law that denied approximately 40,000 legal immigrants access to Commonwealth care health insurance, discriminated against a suspect class and was subject to strict scrutiny under the Massachusetts Constitution. In its opinion in Finch 1, this court reiterated the now familiar test that a state law must pass to survive strict scrutiny. It must be narrowly tailored to further a compelling state interest. The only question before the court today is whether Section 31A meets that exacting standard. Under well-settled principles of law, it doesn't, for 3 independent reasons. First, the compelling interest the defendants now cite, furthering national immigration policy, was not an actual purpose of the legislature in enacting Section 31A. Second, even if it was, that purpose is not a compelling one for equal protection purposes. And third, Section 31A is not narrowly tailored to that purported compelling interest. Under strict scrutiny, this court must find that the purpose the state relies upon to save a discriminatory law was a real and actual purpose for the law, not a hypothetical or pretextual one. Deference to the state and presumptions designed to save a statute that are appropriate under rational basis review have no place under strict scrutiny, which aims to smoke out illicit and discriminatory motives. Here, however, the court need not even adopt the skepticism that is inherent in strict scrutiny to reject defendants' claim of statutory purpose. Everyday modes of statutory interpretation will do the trick. For example, there is absolutely nothing in the text of Section 31A or its successor laws to support the defendant's contention that the legislature was aiming to further a national immigration policy of promoting the self-sufficiency of immigrants by denying them access to health care. Although 31A refers to certain provisions of the 1996 Federal Welfare Reform Act, known as PERORA, the only parts of PERORA 31A refers to are those parts that establish eligibility for federal funding, for federal benefits. That reference makes total sense if the legislature was worried about the cost of Commonwealth care and how it was going to pay for Commonwealth care. Because as defendants emphasized so clearly in Finch 1, those provisions of PERORA meant that the state did not receive federal financial reimbursement for the health insurance costs of the plaintiff class. In other words, as this court noted in Finch 1, one way of thinking about it was that it cost the state more to provide health insurance to the plaintiffs than it cost to provide health insurance to citizens. But the provisions of PERORA that are included in 31A say absolutely nothing about national immigration policy. The state did not refer to any parts of PERORA that refer to national immigration policy, and there's nothing in the statute to think that the state did. Moreover, 31A's text belies the defendant's claim that the legislature adopted the goals of the 1996 Welfare Reform Law.
How different would this case be if they had said that?
Well, I think, Your Honor, if the legislature had said that, it would be much harder for us to make the plain meaning argument that we make, obviously. But under strict scrutiny, the court would actually still have to go beyond the plain meaning to make sure that the statutory language was not pretextual. And in addition, Your Honor,
So a state can have as a compelling interest a federal, what is really within the federal jurisdiction to control. Which
oh, no, Your Honor, absolutely not. I think what I was just going to add was that even if one were to accept, which we don't, but even if you accept it hypothetically, that the state legislature aimed at furthering the policies articulated in Prior's preamble, it still would not be a compelling interest for equal protection purposes under the state law. First of all, as this court noted in Finch 1, the state has absolutely no authority over national immigration policy. A constitutionally inappropriate purpose cannot be a compelling state interest. In addition, there is absolutely no support at all for the defendant's theory that Congress, in a sense, gets to define an interest as compelling. Congress can certainly create national...
Surely the Congress can say, this is really important. We have total authority over this area. They can't define that interest as being compelling?
Well, Congress can do two things, Your Honor. First of all, Congress can certainly create a uniform national immigration law, and that would become the supreme law of the land, assuming it's constitutional within Congress's prerogatives, and it would be binding on the state. And in Finch 1, this...
So if it's not binding on the state as a matter of federalism or sovereignty, then it can never be compelling, even if Congress says it's really important that we take the following approach to immigration policy nationally. We're not going to force every state to do this, but this is an interest that we express, and we are the ones to express such an interest.
Congress can express that interest in a preamble, and I think that that may be relevant to a court's analysis as to whether or not it's compelling. But Congress can't, but the interest doesn't become compelling simply because Congress calls it compelling.
And how do we make it, how does the court have to say, yeah, that's compelling? We're with you. That's compelling? Or who has to say that's compelling?
Well, I think for purposes of equal protection law under the Massachusetts Constitution, and this is a state constitutional claim, this court has to decide, is this an interest of the state sufficiently weighty and of the nature of the kind of interest that the state has called compelling? Immigration is not an interest of the state. Immigration is indeed, again, as the court said in Finch 1, and as the Supreme Court has reiterated numerous times, is not even an area in which the state should be making policy. So, of course, Congress can create national immigration policy, and Congress can say in a preamble that we think this is important, and that's something to take notice of. But simply because Congress has said that in the preamble does not make this a sufficient purpose for equal protection clause.
So they may make it a compelling national interest, but not a compelling state interest.
Well, Congress can't even make an interest a compelling interest for federal equal protection purposes. I mean, the Supreme Court made that clear in Adirondack versus Pena, in City of Bernie versus Flores. I mean, the legislature does not get to define what is and is not a violation of the Equal Protection Clause. And
it wouldn't define that. It would just define what's a compelling interest.
Well, the legislature can create a policy. But, for example, in the affirmative action cases and the race discrimination cases, the Supreme Court has been clear that Congress can create policies to redress past discrimination, but it's the Constitution. The court had to decide for itself, and it did in cases, that redressing past racial discrimination is compelling. And the courts had to review, and the Supreme Court was very clear in Adirondack versus Pena, that the federal courts had to very carefully review that Congress, in fact, got it right, that there was, in fact, past discrimination, for example, in the highway subcontracting markets at issue in Pena. Congress can create a policy to further a compelling interest, but Congress doesn't get to decide, and the defendants here have cited absolutely nothing in the record other than Congress's say-so. And just because Congress, in a preamble written 16 years ago, Your Honor, which of course has nothing to say about current conditions, and as we've shown in the...
Still affects billions and billions and billions of dollars in federal money. It still controls where federal money can go.
It still controls where federal money can go, Your Honor, but it doesn't speak to the question about whether there is a compelling need today to redress, or whether there's a problem of self-sufficiency of immigrants today. The Supreme Court has been clear, and this court in Weston has said that the existence of a compelling need, that a law under strict scrutiny is designed to further, that is subject to continuing review. So even if Congress was right that there was a compelling need back in 1996, and again, defendants have cited nothing in the record.
Do we have any, is this the only statute in which Congress said there was a compelling need but did not compel the states to do what they said was there was a compelling need to do?
Your Honor, we have not, there's no other evidence.
Yeah, I guess one issue is, do we take Congress for what they say or for what they do? Because they didn't compel the states, which they could have done. You agree they could have done?
Yes, Your Honor. And not only didn't they compel the states, Your Honor, but as this court found in Finch, the operative provisions of the statute actually speak in a quite different way than the preamble. As this court specifically said in Finch 1, with respect to state programs such as Commonwealth Care, the federal government expressed indifference as to whether or not the state was providing benefits to legal immigrants, not subject to federal benefits. So, I mean, defendants are relying purely on a preamble, and the precatory language in the preamble, the statute itself was different, and subsequent federal laws, including the 2010 Affordable Care Act, go in a very different direction and express a very different view about how we further the self-sufficiency of immigrants than does the preamble of Priora.
You're not going to ask us to read that and understand the Affordable Care Act, are you?
No, Your Honor. No, Your Honor. But I will. It is important to note that the provisions of the Affordable Care Act, including the eligibility for the exchanges that will go into effect in 2014, which in fact are modeled under Commonwealth Care, will be available to the plaintiff class, to legally residing aliens, and not subject to the Priora limitations. I say this only to suggest that that's not determinative here, but that the idea that Congress, there's a compelling national interest to go in one particular direction based solely on the language in Priora is questionable, because federal policy itself is in a different direction. But more importantly, it is the duty and obligation of this court in a strict scrutiny case to decide whether or not an interest is compelling, whether there was a compelling need for the statute, and whether the statute was narrowly tailored. The defendants here have offered absolutely no evidence. They responded to our motion for partial summary judgment, in effect, by moving for cross-summary judgment. They have entered nothing in the evidence to suggest, and there is no evidence suggesting that the state ever considered a less restrictive alternative, ever compiled a record, and we were unable to find, Your Honor, a single case dealing with discrimination against a suspect class where the statute has been upheld in the absence of any record whatsoever showing a compelling problem, showing any legislative hearings. Yes, Your
Can I
Honor.
ask a question? I'm new to this. Let me see if I understand factually. The 1996 Federal Welfare Reform Act was in place when the Commonwealth Care provisions were adopted.
Absolutely, Your Honor.
Was there ever a time when the Commonwealth received federal reimbursement for the class?
No, Your Honor. In 2000, the Commonwealth received reimbursement from the federal government for some of the members of Commonwealth Care and not others.
But, I mean, of the class that you represent.
No, the Commonwealth never did. The Commonwealth provided our plaintiffs with access to Commonwealth Care from 2006 until 2009. And in 2009,
Having nothing to do with federal reimbursement.
nothing, and no change in federal immigration law, no directive from the federal government saying that the state was, not insane. what happened in 2009, as the governor said in his signing statement, is there were a fiscal problem arose. And so the Commonwealth decided to restrict access to Commonwealth care to a vulnerable class for whom in fact it cost the state more to provide them care. And there's absolutely nothing in the record to suggest.
But it always cost them more.
It always cost them more. The only thing that changed is the Commonwealth's fiscal predicament got more dire in 2009. And that's precisely what the defendants concede, that fiscal considerations do not survive strict scrutiny.
Thank you, counsel.
Thank you.
Good morning. Section 31A survives strict scrutiny not because Congress said so, but because it's narrowly tailored to serve an important, substantial, and compelling governmental interest.
Is this a possible interest or the actual interest?
This is an actual purpose, one of perhaps several actual purposes
Well, there
of the
might
statute.
there might be lots of hypothetical purposes that one could argue about, but don't you have to show that this is one, may not be the only, but one of the actual purposes?
And here's, I think, the key fact that shows that, Justice Cordy. There are many possible ways the legislature could have revised the Commonwealth Care Program to save money other than adopting the pro-rata eligibility rules jot for jot. It could have changed the program in a way that had nothing to do with immigration status. It could have changed the program as the Senate Ways and Means Committee had suggested, and this is discussed in Mass Law Reform's brief. The Senate Ways and Means version dealt with immigration status but had nothing to do with national immigration policy. That was a version that said no citizen, no matter how long they've got here, whether they're eligible under pro-rata or not, can get Commonwealth care. But that's not what the legislature did either. The legislature did, in plainest words, a choice of adopting the national rules set by Congress, jot for jot, knowing full well, because they had just dealt with this in the transitional AFDC program that, of course, was the subject of this court's decision just a few years earlier in Doe versus Commissioner, knowing full well that Congress had determined that when a state chooses to adopt and follow those rules in pro-rata, then the state is indeed furthering the important and compelling national immigration policy and the goals of ensuring that immigrants are self-sufficient and that there's no incentive for individuals to immigrate because of publicly funded means-tested benefits. And so that's how we can tell that this was an actual purpose of the statute. Now, plaintiffs argue, in essence, that the legislature never would have looked at this if fiscal concerns weren't on their mind at that point in time. The Commonwealth submits that that's okay. It's permissible for fiscal concerns to be a catalyst that stimulate the legislature's thinking about another interest that's sufficiently compelling to satisfy strict scrutiny. Let's imagine in Weston W., the curfew case that this court dealt with a few years back. Let's imagine that the Lowell City Council first said, you know, we're spending a lot of money because minors are getting in trouble overnight. What can we do so we don't have to spend all of that money? And they explore it, and they decide they're going to have a curfew that is justified also for the reasons that this court articulated. That ordinance would pass constitutional muster just like the one that was upheld by this court, even though the catalyst for the thinking was fiscal. So plaintiffs can see, quite rightly, in their reply brief, that a suspect classification can serve more than one purpose, as long as at least one of those purposes is sufficiently important and compelling, and the law is narrowly tailored to serve that purpose, then strict scrutiny is satisfied. That's what the First Circuit held in Cotter, a case that this court cited with approval quite strongly in the Brackett case. Now,
Do you have a case where one serves as a catalyst as opposed to window dressing?
Yes, the four different federal highway funding cases that we cite from the 7th, 8th, 9th, and 10th circuits, I believe, all involved a law where, even more strongly than here, there was a fiscal incentive and catalyst. A state that wished to receive any kind of federal highway funding had to make reasonable efforts to award contracts to appropriate levels of minority-owned businesses. So there was a strong fiscal reason for each of those states to think about carrying out the compelling nationwide interest identified by Congress in remediating past discrimination. Now, it bears emphasis, I know it's obvious, but it bears emphasis that in Grutter, the Supreme Court quite strongly rejected the notion that remediating past discrimination is the only interest that could ever be important enough to justify a suspect classification, and emphasized that strict scrutiny is not strict in theory but fatal in fact. It has to be applied by its terms. Is there an important enough interest? And we submit that the interest at stake here is at least as important and substantial as other interests that this court and the United States Supreme Court have found to be compelling and satisfy strict scrutiny.
But it was not so compelling that Congress itself chose to enforce this upon the states. So why should we say it's compelling when the United States Congress, even when they passed Perara, didn't act as if it were compelling?
Well, Congress didn't mandate that states have to do this because, of course, if they did, we'd be dealing with the Supremacy Clause and not equal protection.
Right.
But Congress did specify in Section 1601, Paragraph 7, that a state that chooses to follow and adopt these rules is furthering national policy and serving a compelling interest. So Congress
But you don't suggest that we're bound by that.
No, we do not.
And even if we, well, I mean, the problem is they didn't do what they said. If it was compelling, shouldn't we expect them to actually compel?
It has never been a requirement of strict scrutiny that the purpose to be served by the challenged classification be mandated by some other law. It is always the case, since we're not in the Supremacy Clause world, but instead in the equal protection world, that the legislature has a choice that may be controversial, a choice with which many folks, including the plaintiffs, disagree. But at that level, that's a legislative decision that the Constitution says the legislature gets to make, so long as the suspect classification serves an important enough interest. This is this important interest of making sure that new immigrants to this country are self-sufficient is a long-standing aspect of federal immigration policy.
But by your argument, then, there would be an equally compelling interest for the state to deny all benefits to immigrants, because any benefit to any financial benefit to an immigrant may arguably encourage them to not be financially independent.
Justice Gantz, of course, that would be foreclosed by the Graham case. The Massachusetts legislature does not get to make up an idiosyncratic immigration policy for Massachusetts. What Plyler, 11 years after Graham, tells us in part is that where Congress, however, decides what national immigration policy is, and especially where Congress has said this part of national immigration policy is actually very important, then the states can follow at their choice the federal lead. And so, no, the Massachusetts legislature could not have enacted the Senate Ways and Means version and said, you're not a citizen, forget it, you can't get Commonwealth care, because that's not what the national immigration policy is. It may arguably serve the same goals in a different way, but it's Congress that gets to decide how, as a matter of national immigration policy, the goal of immigrant self-sufficiency should be served. And Congress has defined very specific eligibility rules in PROARA, authorized states to adopt them, and specified that when states do so, they will be furthering an important interest. Now, plaintiffs argue today and in their brief very strongly there's no evidence that this interest is important. We submit that this court has found in Blixt, the United States Supreme Court has found, for example, in Burson, that the importance of the interest can be self-evident. There does not need to be actual factual evidence introduced. In Blixt, that had to do with the challenged grandparent visitation law. The court construed it to say that the visitation rights only kicked in when necessary to avoid harm to the child, and said when construed in that way, it was clear that the statute served an important and compelling interest. No evidence was required. It was self-evident on the face of the statute. Here as well, in light of Congress's determination of national policy and its specification that when states follow that lead, they're serving a compelling interest, it is self-evident on the face of Section 31A that an important interest is being served.
Is that, are you saying that it is also self-evident that Section 31A furthers self-reliance by this excluded group?
It is self-evident that Congress gets, well, let me try it this way, Justice Lang. Congress gets to define what the national immigration policy is. Congress has determined that these particular sets of rules further the goal of ensuring that immigrants are self-sufficient. We know from Matthews versus Diaz that Congress's authority to that is very broad and can't be challenged. What we say is that it is self-evident that this interest is important by comparison to other interests that have been found sufficiently important to satisfy strict scrutiny without there being a need for a factual showing, just as there was not a need for a factual showing in Blixt.
How is it a compelling state interest?
Massachusetts shares the nationwide interest of attracting immigrants who are self-reliant. Some other state might decide that they are, perhaps they have a greater reliance on migrant farm workers, and they want to attract them to their state, and rather than a competing state, by offering state-funded, means-tested public benefits, and might not choose not to go along with it. But Massachusetts, the Massachusetts legislature, is entitled to make the judgment that Massachusetts shares the national interest. The constitutional requirement of equal protection doesn't mandate that Massachusetts have some interest that is different from the nationwide interest. And where this has come up, and we believe it's the only place it's come up, is in those federal highway funding cases.
But is it a compelling state interest that we may want to attract or discourage immigrants to come here?
It would not be a compelling interest if the Massachusetts legislature were freelancing and making up an idiosyncratic Massachusetts immigration policy unto itself. But it is compelling, once Congress has said this is permissible and furthers the national goals, for the legislature to say, yes, Massachusetts shares those goals, and that's sufficiently compelling and important. And it's as important as protecting voters from intimidation near the polls as in Burson. It's as important as protecting the welfare of children and other citizens.
Getting immigrants to come to Massachusetts is as important as getting people to go to the polls and vote and protecting their right to vote?
Well, let me state with more specificity, if I could, Justice Spina, what we say the interest is that's being furthered here. The interest is to further the national immigration policy specified in PERWARA so that, number one, public benefits not create an incentive to immigrate to the United States or to Massachusetts in particular, and so that immigrants not rely on public resources during their first 5 years in the United States.
And we couldn't view Congress's wink, in effect, about the compelling nature of this policy from the fact that it didn't impose it on the states.
Well, it's
not so compelling that it really should be enforced nationally, uniformly.
It's not a wink. It's a specific finding by Congress that when states adopt these same rules, they're serving a compelling national interest in furthering these national immigration policies. Now, Justice Link, you had asked about timing of when this.
Yes, apparently the legislature didn't think that this was such an important policy when it adopted Commonwealth care.
Well, but these same rules have long applied in other program areas. Congress, and this was the subject of the prior decision in Doe, I said Congress, I meant the legislature. The legislature had expressly adopted the same PERWARA eligibility rules for the transitional AFDC program, and the legislature has put those rules in place for Medicaid.
Had it changed its mind subsequently as it did here?
In the TAFDC context, the Doe case, after 1996, the legislature didn't change its mind, but it expressly reenacted legislation to say we definitely want these rules still to apply.
So it's not exactly what happened here, because when Commonwealth care was enacted, there was already the pre-existing federal policy, federal immigration policy, but that's not what Massachusetts, the Massachusetts legislature embraced at that point.
That's right. The Massachusetts legislature made a policy choice to change. It changed its mind. It did something different. That doesn't make it unconstitutional. That doesn't violate strict scrutiny. There can always be a first time where a legislature.
But how is it then that, in doing strict scrutiny, you don't take that into account as a factor, that this may simply be nothing more than window dressing for what is a different decision, which is nothing other than fiscal?
Well, I think there are two parts to the question. If I may try to separate the two of them. The fact that there's a change in policy doesn't in any way indicate that the new policy is not sufficiently compelling. Grutter is a good example. The new policy of the University of Michigan Law School to ensure racial diversity in its student body, they had an admission policy that didn't used to be in place. They put it in place to achieve this goal. It was challenged, and as you know, the U.S. Supreme Court upheld it. The other part of the question, I believe, Justice Lank, is going back to, well, if they change their mind in the summer of 2009 for the fiscal 2010 budget, doesn't that mean that their only real reason was fiscal? And to reiterate, no, we think what it shows is merely that there may have been a catalyst in the body of fiscal concerns that prompted the legislature to look at this. But the legislature chose to put the per wara rules into place for Commonwealth care rather than doing something else for a reason. The legislature was well aware of what Congress had said and done in per wara, not just in terms of setting up the rules in the substantive provisions, but in terms of Section 16017. It was well aware that just a few years earlier, this court had held in Doe that when the legislature adopts those exact same eligibility rules for a state-funded program, it is furthering the national policy and it's adopting the rules in order to further the policy. So if the legislature wasn't interested in furthering this policy, but it just wanted to save the same amount of money, there are many, many ways it could have done that either within this program or outside of this program. What it in fact did in the fiscal 2010 budget was bring Commonwealth care into line with the same eligibility rules that apply to Medicaid, and still, after the Affordable Care Act, will continue to apply to Medicaid, and into the same line with the rules that apply in the TAFDC program.
Thank you very much, sir.
Thank you.